Hi, it's Roland Jones. This is another short video in a series on preference and fraudulent conveyance issues. This is a recent case of a trustee suing a law firm for a preference. I found this fact pattern to be a little bit bizarre. The debtor cargo transport made 6 payments to settle a preference case. So the debtor, I guess before it filed, was sued for a preference and made settlement payments, and then it filed, and then its trustee then sued the law firm that was, I guess, defending it, or actually, I guess it was a law firm prosecuting the first preference action to settle the case. So the law firm that was prosecuting the preference action later gets sued for a preference by another trustee, if you could follow all that. And anyway, it's not really the point. The point is a case was settled, doesn't really matter what it was, and the debtor, in the preference period before it went bankrupt, paid settlement checks to a law firm. So the trustee sues the law firm, and the law firm says, what do they say? Well, they say you can't sue us for a preference because we're just a conduit. In other words, we're holding the money in escrow, and we're going to transfer that money to somebody else. You got the wrong guys here. You got the wrong defendant. We're just a pass-through. And so the question was, well, is that a defense to a preference case? One of the issues, the issue that the court looked at, especially in the context of it's called a conduit defense, is the degree of control that the alleged conduit had over the funds. Did it have no control? Could it do whatever it wanted to do with the funds, or somewhere in between? And the court's going to look at that and decide whether the defendant is really a conduit or not. This is the code section that we're looking at, specifically 547B1, to or for the benefit of a creditor. If the debtor paid settlement proceeds, settled the case by sending checks to a lawyer and a law firm put it in, and the law firm put it in escrow, is the law firm really a creditor here or not? Well, the court decided that Amron, the law firm, was not an initial transferee, and it was not a creditor, and so it could not be sued. The transfers could not be avoided because it had all kinds of requirements not to do anything it wanted to, obviously, with the money. It had to respect the law as well as the bar code of professional responsibility. And so it basically had very little control over the funds and what it could do with those funds. So court decided the transfers could not be avoided. One of the issues that came up in this case is initial transferee versus secondary transferee. That's going to be the subject of another video, the difference between the two. But here, the initial transferee did not have sufficient dominion and control over the funds, and the court recognized that it was a conduit, and the transfers could not be avoided from the initial transferee from the law firm.